been said, the prudential use of the political question doctrine can maintain the legitimacy of the judiciary where it is fragile in terms of relative power. The doctrine can allow courts to choose their battles wisely and avoid constitutional crises that can undermine the legitimacy of the judiciary. The Zimbabwean constitution contains strong declarations and statements regarding the structure and attributes of executive and political power. Section 88, subsection 1 of the Constitution of Zimbabwe says that executive authority derives from the people of Zimbabwe and must be executed according to the Constitution. This is a proclamation of popular constitutionalism where political supremacy is derived from the people and is executed through elected officials. Similarly, Section 116 and 162 of the same Constitution, which talks of the legislature and the judiciary respectively, gives those different branches of government their respective duties when it comes to saving the state. The above provisions that I have mentioned, ladies and gentlemen, in the Constitution serve as a fertile ground for the emergence of the political question doctrine. It is imperative to note that Justice John Marshall of the United States of America set forth the political question doctrine in the case of Marbury versus Madison in 1803, where he assessed that questions in their nature, which are by the Constitution and laws submitted to the executive, can never be met in this court. Kenyan authors Juma and Okpabala describe the doctrine as a theory of interpretive deference, which demands that a court declines to exercise jurisdiction on a dispute which it is ill-equipped to deal with or where the political organ renders the best possible solution. The province of the court is therefore to solely decide on the rights of the individual and not to inquire on how the executive perform duties in which they have no discretion. According to scholars, the doctrine furthers the goals of assigning the most politically controversial matters to those who are charged with making those difficult policy decisions. Professor Alexander Becker urges that the court should use the doctrine for expediency to preserve institutional legitimacy, whilst on the other extreme, Professor Martin Reddish believes that it is unconstitutional for the Supreme Court to abdicate its duty of judicial review. This is according to Article 3 of the American Constitution. We have Moen, who uses two assumptions which intertwine. The first one states that the judiciary is the only institution with the authority and capacity to interpret a constitution. And the second one states that to limit judicial monopoly on the constitutional interpretation is to destroy, if not threaten, the rule of law, ladies and gentlemen. With this in mind, it is our duty to examine whether the Zimbabwean courts have carried out a legal borrowing of this doctrine. Professor Nelson pronounced the doctrine as fizzy or fuzzy at best. Sidman posits that the doctrine is living a secret life. Whether or not this is true, we can only answer it through an analysis of certain case laws, mostly from Zimbabwe and from other jurisdictions. I am Melanie Kufakomwe, ladies and gentlemen, and we will be presenting on the political question doctrine in Zimbabwe with my fellow counselors. Stay tuned.
Taking over from Melanie, I'll be addressing on what exactly a political question doctrine is. There are various views brought out by different jurists as to what a political question doctrine is. This is because of how different courts have applied and acknowledged this judicial principle. As alluded to before by the first presenter, this doctrine was enunciated by the United States of America Supreme Court in the Marbury case. The case became the landmark of the doctrine from which various jurisdictions borrowed the jurisprudence. For example, the Ghanaian Supreme Court in the case of New Patriotic Front versus Attorney General. In the case, the plaintiff filed a lawsuit against the celebration of the coup d'etat in Ghana as it was deemed a violation of Section 2 of the Republic of Ghana's Constitution. In the case, The likes of Judge Amunsiki upheld the doctrine, although the matter was later decided by the court that it was a non-justiciable issue which the court could address. Political question is a function of the separation of powers doctrine. It provides that there are certain questions of constitutional law that are constitutionally committed to the elected branches of the government for resolution. The doctrine further states that a dispute is not appropriate for adjudication when it involves a multiplicity of variable and interlocking factors, whereby the decision on each factor presupposes decisions on other polycentric disputes. This is clear to say that when a court is faced with a matter which leads to multiple issues that are not determinable, but rather best solved by other arms of the government, it will be wise to deter from such matter. Therefore, the political question doctrine is treated as one of the devices that the judiciary utilizes to define the relationship with other branches and acknowledge that the courts share responsibility for interpreting a constitution with other branches of the government. In general, the issue of the political question doctrine has nothing to do with the political implications of the case, but rather whether the matter before the court has any legal basis and can be decided by the law. When discussing the issue of the political doctrine, it is tried to address the issue of justiciability. The issue of justiciability arises when the court finds that its judicial authority cannot be exercised because the subject matter of the proceedings is not amenable to one or more of the circumstances. For instance, where a dispute raises political questions which are not appropriate for judicial resolution. In the South African case of Democratic Alliance versus eThekwini Municipality, whereby the issue involved the renaming of the streets as a political decision which the council was responsible for. The court dismissed it based on the political doctrine, as it was a political issue that was governed by the political party in power. Hence, the political question doctrine purports that when a question before the court is non-justiciable, the judiciary should abstain from deciding it if doing so would intrude upon the functions of elected branches of the government. So we are now moving on to the case of Baker versus Carr, whereby a six-step, more like a test, was decided on how to govern whether a case is justiciable or not. So in the case of Baker versus Carr, Charles Baker was a resident of an urban neighborhood in Tennessee who filed a suit in the court against Joe Carr, who by then was the Secretary of the State of Tennessee. Baker sought a court injunction to postpone elections until the state had fulfilled its duty to reapportion its legislative districts. The reapportionment has not been done since 1901, although the Constitution stated that this should have been done after every 10 years. His argument was based on the 14th Amendment of the Equal Protection Clause, which was in the Constitution. He argued that because of the population changes that were happening in the city, which would affect his vote, his vote in urban areas had less weight than that of a voter in the rural area. The case was decided by the Supreme Court on appeal after it was dismissed by the district court. The court held that the issue was justiciable as the plaintiff showed that he was disadvantaged and the matter involved voting inequalities. The court then formulated a six-part test to determine the justiciability of the case. So the court stated as follows, that in order for one to determine the justiciability of the case, they have to look at the commitment of the issue to a branch of the government other than the judiciary. They have to also see if the case lacks the standards for resolving the issue, and also the impossibility of the judiciary to resolve the issue without first making a policy determination. A judicial decision of that matter is a lack of respect for other branches of the government. It also looks at a political decision which has already been made, and the potential for multiple pronouncement by various branches on one question. According to Baker's case, the above are characteristics that define a political question doctrine, and it is in the best interest of the court to desist from deciding such cases, as such pronouncement may fly by the wind since there will be no legal resources upon which they may be based on. The same was also stated in the South African case of the opposition to Urban Tolling Alliance versus Sanral. So, ladies and gentlemen, basically, this was my presentation on what a political doctrine question is. My name is Charmaine Muterewa. So now I will defer the proceedings to my other presenters who will take you through the rest of the presentation.
Like we have heard the first presenter as she was talking about the adoption and the framework and the root of the political question doctrine. The second presenter came in and discussed what exactly is meant by the political question doctrine. All of these presentations, they have shown one basic thing, which is the adherence to the doctrine of the separation of powers. So, the background of my presentation will only be focusing on the separation of powers and the political question doctrine in Zimbabwe, giving a comparative analysis of the situation in our jurisdiction before the adoption of the 2013 Constitution, and then the next presenter will take you about the adoption of the political question doctrine after the adoption of the 2013 Constitution. So, like in any other jurisdiction, Zimbabwe prides itself in the separation of powers, which is a strong pillar of a sound democratic society. The Constitution of Zimbabwe, especially the current constitution, does not expressly provide for the separation of powers, but it gives the elaboration of duties for the executive in Chapter 5, the legislature, Chapter 6, and also in Chapter 8, where it talks about the judiciary. This is a clear manifestation of the doctrine of separation of powers, although it is not expressly stated. Each branch of government has its promulgated function, which they should diligently execute. The legislature has the mandate to make the laws. The executive enforces the laws, and then the judiciary is there to interpret the laws. This clear separation is there to make sure that there are checks and balances. Each branch is there to regulate on the powers of the other branch to avoid a situation where there is rule by decree, especially by the executive. The fundamental question here is, who watches the watchman? Complicated as it may be, it is fundamental to notice that each branch has its endowed functions, which must be performed to some extent without interference of the other branch. The political question doctrine comes into effect where there is extreme exercise of judicial deference, and emphasis here is mine. There is mostly the strict use of the literal interpretation where the text is adhered to and there is no deviation. If the judiciary are allowed to frequently use judicial activism, there will be a slippery slope where the judiciary will be making laws, and this is not their mandate. This is the mandate of the legislature, and thereby defeating the whole purpose of the separation of powers. Judicial deference here is most preferred because the legislature, by foregoing and not mentioning some laws, it goes on to show that it is deferring its lawmaking powers to other branches of government. And then we here move by to discuss a number of cases where the political question doctrine can be seen in our jurisdiction. And this is in reference to cases before the adoption of the 2013 Constitution. Now, 4 cases here have been selected for analysis of the political question doctrine. One, the first case is Rattigan versus Chief Immigrant Officer, 1994, Zimbabwe Law Reports, the second volume. Commercial Farmers Union versus Minister of Lands and Others, 1995, Zimbabwe Law Report, the second volume. The Mike Campbell case and then and another versus the President of the Republic of Zimbabwe and others. Now to the first case, Ratigan versus Chief Immigrant Officer, 1994, Zimbabwe Law Reports, Volume 2. Kubei Chief Justice, as he was called upon to determine whether or not a law that did not give automatic resident status to the foreign husband of a Zimbabwean woman was unconstitutional. The court claimed that the natural order of things obliged husband and wife to confer sexual privileges exclusively upon each other. Accordingly, the law in question was effectively expelling the Zimbabwean woman of the period she stayed in marriage. The government had to amend the constitution to reverse this decision. Now, in this case, we see that the legislature is clear on what it wants. An alien husband is not allowed to stay in Zimbabwe, even if he is married to a Zimbabwean woman. But then the judges in this case, they adopt a naturalist approach to adjudication, in which they conclude that a man, if married to a woman, is to execute other duties, including conjugal rights. And by this effect, that alone made the legislature to forego that provision in the constitution, meant that they were actually ignorant to the rules of natural law. In this case, the courts determined a case in which the legislature had left the executive to determine, because it was the prerogative of the executive to determine who should be in the country and who should not be in the country. Because if we are to refer to this matter, this is purely a matter of foreign politics and foreign policy of the country. Moving on, we move on to the case, the Mike Campbell case. The Mike Campbell case, in this case, the applicants have had their farm in Chegutu taken as a result of the redistribution of the land exercise in the wake of the land resettlement program. This exercise was effected in lines of Section 17 of the Lancaster House Constitution. What is important to note is that Section 17 states that the jurisdiction of the court is ousted in deciding matters to do with the land. The only thing to be contested will be the amount of compensation and not the issue of acquisition. The legislature was clear, and it was typed and printed in clear, unambiguous language. The matter of acquisition in this instance was clearly stated to be a political question. Land grabbing was the prerogative of the executive and never about the courts. The only matter justiciable was about the amount of money to be paid as compensation. So in clear words, the Supreme Court said that the question of what protection an individual should be afforded in the Constitution in the use and enjoyment of private property is a question of political and legislative character. And as to what property should be acquired and in what manner is not a judicial question. In the strict sense and in clear wording, the jurisdiction of the court was ousted, and in no way could they decide a matter in which they were expressly ousted. Now, if we are to refer to the second presenter when she was talking about the case of Becker versus Kam, in that case, on the 6 characteristics that are given to a political question, one of the characteristics is that where there is a political question. And we see the adoption of this case and some of the characteristics in this particular case, and in specifically in provision of Section 17 of the Lancaster House Constitution, where it literally states that the courts have no jurisdiction to be able to entertain that matter, and it is a political question and not a judicial question. Now, this gives relevance to the clear doctrine of the separation of powers, and even if it is not clearly expressed, the adoption of the political question doctrine. Moving on to the next case of Kufa and another versus President of the Republic of Zimbabwe and others. Now, in this case, The applicants went before the court asking the question of the President of Zimbabwe and the Prime Minister on contravening Schedule 8 of the Lancaster House Constitution of going above the recommended number of 31 ministers. The first and the second respondent had added 10 more ministers, making the total number of ministers 41 instead of the stated 31 in Schedule 8. The question before the courts was whether the appointments were unconstitutional. The effect was mainly because of the government of national unity, and the submissions by the respondents stated that the appointments were because of the change in the political arena. The move was necessitated by the need to create a politically stable environment where there is inclusion of everyone. The court mentioned as obiter that the political question doctrine, although not recognized in Zimbabwe, it does exist, and the adoption of this policy was mostly a political question. Now, the amendment to Schedule 8 was not a matter in which the courts had to decide, but it was a matter that had to be left to the executive. After the disputed elections of 2008 and the global political agreement was made, there was need to make sure that there was inclusion of everyone in the running of issues in the country. Thereby, the number of ministers that was provided for in Schedule 8 was not enough to make sure everyone feels represented. Now, this was a matter for the executive to deal with, because these are political policies, and these are policies which have to be left to the government to deal with. Moving on to the case of Commercial Farmers Union versus Minister of Lands and others. Now, this case is hand in hand and is a case in point and similar to the one in the Mike Campbell case. It was recognized that the land issue in question lies in the political domain to resolve. It was accepted as fundamentally true that the land issue was a political question. It was said that the political method of resolving that question was by enacting laws. To this extent, it was recognized that the government had done just that. It had enacted and amended the Land Acquisition Act, but the only problem was that the government was not obeying its own laws. When a government does not obey its own laws, there can be no question for them courts keeping mute in their lane. They will speak out. They will call the government to account. It is their constitutional mandate. Now, we move here to another very, very interesting pillar, which is that of executive accountability. The adoption of the political question and also looking at judicial deference does not mean that when we adopt a political question, it means turning a blind eye on other executive policies which are unconstitutional. What this case and the judgment had in essence was that if the government are to make policies and those policies are constitutional, then if it is a matter if there is a dispute which arises, then the executive is best settled to deal with that matter. But if the matter now violates a provision of the Constitution, the courts will not keep quiet, but will attack the matter on constitutional norms. Now, this was my part of the presentation, which was about the adoption of the political question doctrine before the enactment of the 2013 Constitution. My name is Silvester Chiware, and I will leave you in the hands of the next presenter. Thank you.
The last presenter dealt with how the courts in Zimbabwe dealt with the political question doctrine before the adoption of the 2013 Constitution. I will be dealing with how the courts deals with this issue of the political question doctrine after the adoption of the 2013 Constitution. So the first case is Mawarire versus Mugabe in his official capacity and others. It's a 2013 case. The applicant brought this issue before the court under Section 24, subsection 1 of the Lancaster House Constitution on the basis that his rights enshrined in Section 18, subsection 1 of the Constitution had been contravened. The section stated that every public officer had the duty towards the exercise of The section stated that every public officer had the duty towards every person in Zimbabwe to exercise his or her functions as a public officer in accordance with the law and observe and uphold the law. The applicant contended that the failure by the respondent to set the date for elections when the life of parliament was coming to an end violated his rights as an expecting and protection as a registered voter and his legitimate expectation to protection of the law. It was common cause that the Parliament of Zimbabwe would stand dissolved by the election of the time on 29th June of 2013, when the applicant brought his application to the court. The president had not set a date for the elections. The applicant contended that relevant constitutional provisions showed that the president had to call for elections within the life of the parliament. The second and fourth respondent were of the view that the former constitution granted discretion to the president to call for the election on the date up to 4 months after the discretion of the parliament. On the contrary, the applicant and the first respondent were of the view that elections should be held within 4 months before the life of the parliament came to an end. Malaba refused to have wool cast over his eye of his mind on this matter, as he gave a dissenting judgment. He indicated that the use of the word may is clearly indicative that the power conferred to the president is discretionary in nature, meaning that the president can act on his discretion or judgment. In giving his dissenting judgment, he says that the court cannot get involved in determining for the president the manner in which he should exercise his discretion. It cannot trust the president it cannot tell the president which day or days he should fix or that he was wrong in fixing a certain day. It is not the function of the law to substitute its own wisdom and discretion for that of the people, and the judgment a matter is entrusted by the law. Whilst a court can review a public officer's action of legality, it cannot act as it were the executive. We also move on to the case of Chikutu versus Minister of Lands and others. In this case, between February and March 2021, the government issued a series of statutory instruments, and the main object of which was to set aside a tract of communal land measuring 1,240 for the purpose of establishing an irrigation scheme in Chirezi district. The land in question has been inhabited by the people of Chilonga community since way before 1890, and the impact of the statutory instruments is that some section of the Chilonga community might be affected to the extent that they face eviction to pave way for the proposed irrigation project. The said terms of the Communal Land Act, Section 4 of the latter vest all communal land in the president, and Section 6 of the same act empowers the president to make additions or subtractions from any communal land. The High Court then invoked the political question doctrine. The judge pointed out that the land question was a political question which should be left for the other arms of the government to determine. In simpler terms, the court said the Chilonga case could not be determined by the law and the courts, but rather politics should determine. At paragraph 14 of the crystallized judgment, the court said, sometimes politics has to speak first, and only then may the law take over, as there are some issues that a court alone may be ill-equipped to provide a solution to. Lastly, we move to the case of MDC Alliance versus MDCT. In my view, in this case, the Supreme Court was biased and politically meddled, as its ruling effectively stripped opposition leader Nelson Chamisa of his claim over the main function of the MDC party. The decision went the way of the former Deputy President Thokozani Kupe, the mere fact which was viewed as a political exigency to balance out factional succession rights within the MDCT groups. So, we are witnessing elements of political question doctrine in practice, though in principle our jurisprudence hasn't embraced the doctrine. I am Nellie Munyama, and the last presenter will deal with conclusions and our own perspective of how we view this political question doctrine in Zimbabwe. Thank you.
In conclusion, we respectfully submit that Zimbabwean jurisprudence does not embrace the doctrine of political question, as was held in the cases discussed by previous presenters. Cases to note, Kufa versus Mugabe and others, where Justice Chiware, as he then was Judge President of the High Court, held that Zimbabwe does not embrace the political doctrine question. The legal framework or the constitutional framework we find ourselves in entails that we have three arms of government, which is an ideal framework for adopting the doctrine. Through the adoption of this framework, there appears to be a clear indication by the framers of the Constitution that the judiciary should practice judicial restraint when dealing with matters best dealt with other branches competent to deal with the matters. In line with this view, we submit that judicial overreach is imprudent. This view finds support from Bickel and Schaff, who opine that entangling courts with other institutions of the political system in ways that would not benefit the nation is imprudent. It is clear from the discussed cases that some jurisdictions apply the doctrine without compromising the supremacy of the Constitution. The effect of not developing a clear political question doctrine underpinned by separation of power is that of ineffective judgments, as was held in the case of State versus Mamabolo, where judge held that courts do not have guns, they do not have the pace to enforce their judgments. So holding or discussing political questions in courts will result in ineffective judgments. It is worth noting that there is a ray of hope as the courts are slowly acknowledging the principle of the doctrine through, though there is no express mention of the doctrine, as stated in Mawarire versus Mugabe, as well as Chitepo versus Minister of Lands cases. I thank you. I am Richard Mandere.